You hear that? And I'm going to let them in now. Hold on.
And we're live.
Okay, terrific.
Okay. Great. Welcome everybody to the January 26th meeting of the Regulations Subcommittee of the Milford Planning and Zoning Board. Meg, if you need to read the roll, or would everybody just introduce themselves? What do we normally do? I forget, it's been so long.
Sometimes I read the roll, but there's so few of us. I mean, it's a small group, but
Yeah, I
anyway,
guess
let's do it just for fun.
Okay.
Mr. Sadi, Mr. Collegian,
Present.
and Chairman Quish.
Here. And we have, if David and you and Stephen would introduce themselves for the record.
Sure. Dave Sulkus, City Planner.
Stephen Harris, zoning enforcement.
Meg Green, Recording Secretary.
Okay.
Okay. David, if you would screen share and put the agenda up, please.
I can do that. Here we go. Let me grab that file. And the agenda. Where is, oh, there we go. Okay. There's that. Do you see it?
Okay, we have done the call to order and we have done the roll call. So the topic of the day is short-term rental regulations. I don't know if the members have had a chance to look at what you had sent out, David, but to just acknowledge that you had sent out various, well, you know what, why don't I let you tell us what you sent out? I don't have it in front of me to accurately.
Okay, so basically I sent out information that was culled from different sources. Among those sources was the Connecticut APA, which is my professional organization, who looked at this back in, I think it was 2017. And that was when, or 2018, when the legislature, and I'll share that. The legislature was considering some regulations on this. So this was part of their testimony to the legislature. The legislature didn't do anything with it. They didn't pass any state regulations. But what they found back then was, in their research, basically is that it should be left up to the towns what to do. That was, instead of having the state come up with a regulation. And basically, in their research, as you'll see in some other organizations' research, it's probably better to be a municipal ordinance versus a zoning ordinance, because the town or city has a better chance of enforcing it as a municipal ordinance versus a zoning ordinance. And that's really it in a nutshell. So that was the Connecticut APA. Let's see what we have here. We had SCROG. This was one of the regional planning agencies, Southeastern Connecticut Council of Governments, in 2019, was researching this for that portion of the state, the eastern portion of the state, which is who they cover. And this is a nice synopsis. They go into, various issues that towns would have and showing you different kinds of ads and things. But in the end, they made the same recommendation that, short-term rental regulations via zoning regulations or by municipal ordinance. And they give you the pros and cons of each. And then in their opinion, for at least their part of the state, again, comes down to, municipal ordinances. Let's see, here we go. There is, let's see, another, I got regulations, from, New York, from from California, from Florida. They were all, different places do it different ways. The issues are all the same everywhere because it can be an issue. In Connecticut, and Stephen could probably talk a little more about it. There's a lawsuit in Brantford, because Brantford came up with a regulation that I guess is in court, and he located this particular court case. But also, I'll share with you hot off of the press that I got in my mailbox earlier this evening. Am I still sharing my screen, I hope?
Yep.
Okay, good. This is from Greenwich. Greenwich just passed definitions. They didn't change any regulations. They're basically in these regulations identifying it as a use and limiting it to any house that has a certificate of occupancy, and then they'll only be used for lodging uses, not non-lodging uses, including but not limited to parties, receptions, weddings, filming, photo shoots, corporate retreats, and fundraisers are prohibited. And you can't use accessory apartments, for the use if you have an accessory apartment in your house. But they're basically allowing it, in any home in Greenwich that has a certificate of occupancy. So they just added that hot off the press. Again, so we have different ways to sort of approach this. If if you wanted to pursue the creation of some sort of zoning regulation, we could. The caveat being that we're gonna be like everyone else where they've examined this. It'll be challenging, to say the least, for the zoning enforcement person to enforce it. And that's why municipalities generally do it by general ordinance, where the police could do it, the health department, they can license them, they can tax them differently. There are many more tools in the regulatory bag by a municipal ordinance versus zoning. So, Stephen, do you want to talk about what's going on in Pine Orchard?
Yes. This was a trial court decision that came down in early October. So Pine Orchard, the borough of Pine Orchard is a part of Brantford. They have their own zoning. And there was a person out there who had a house, and they had bought it in the early 2000s, but the use as a guest house had gone back to the early 90s. And in the middle 2000s, Brantford outlawed these guest house type things, or like Airbnbs. And the owner claimed that they had a vested right. So it they cited them for running a business without a permit, went to court, and all parties agreed that the earlier 1994 regulations would apply, since the use was established prior to them changing the regulations. So at the end of the day, the trial court said that the short-term rentals was legal because it met the definition of family, which simply said a number of unrelated people living in the house as a unit. And the court said that didn't have anything to do with the tenure of who's involved, but rather the use of the property. So most towns have a definition of family. And even though this is just trial court, it can be persuasive for other courts to use. So one could argue that all of the Airbnbs and all of the sort of like the beach rentals that go on in Milford today, which have been going on for a very, very long time, they could simply say, well, in light of this Pine Orchard decision, we've been renting out our houses as a family unit for decades. And they would have something to point to. I'd also point out that Pine Orchard has, I believe, they have filed for certification for the Court of Appeals. We don't know if that's been acted on or yet. So the status quo could end up being we can't regulate them, even if we wanted to. Or the appellate court, should they decide to take this case, could overturn the trial court, and we would be right back at square one.
Great, thank you for that.
That sort of argues for ordinance, because if it's a city ordinance, that takes zoning completely out of it.
True. I mean, it might take, the ordinance may take, a certain value of your property if you could rent it. And then if they say now you can no longer rent it within whatever restrictions, that you're diminishing the value of it, and then it's a taking. I don't know. We got a couple lawyers here, might want to weigh in on that, but yeah, very interesting.
If it's by ordinance, then there's no claim to grandfathering. You can't say, well, I've been doing this since 1990 and here's the proof.
Yeah, no, I would bring up a different point.
Yeah.
I would bring up a different point. I mean, if I own a piece of property and it has certain value because I can rent it, if somebody came to me with an ordinance and said you can no longer rent that property, then that would diminish the value of that property. So whether it's for one day or 1 month or 1 year, it's still an opportunity for me to monetize that piece of property. So I mean, I'm not sure anything about what the courts would decide on that, but I mean, I think we have two sides of the issue, right? We have a property owner that has a certain vested interest in the property, that's obvious, and then we have a community or neighbor or citywide or whatever interest, as a collective. So there's a collective interest as a member of the, the neighborhood or the whole community has a certain interest, and then there's a certain interest in the people that own that individual piece of property. So, I mean, I don't really know where the law sits on that, but I think those are the two sides of the coin that we're looking at. Anybody want to speak to it? Mr. Sadi?
Sure. Thanks, Mr. Quish. I actually know the property that's in question in this particular case. There's a lot of litigation. If you go back, that whole street has had substantial problems back and forth in zoning and whatever. But the point of it is that in listening to you, I don't necessarily fully agree that legally you can consider the value of your house being whether you're going to have cooking parties at it or rent it out for Airbnb. You're assessed by the city or the town based on a value. Again, this is just off the top of my head, not giving any legal opinion on it. But I do recognize that there are 3 areas that we have: an ordinance, a zoning regulation, and the last would be some sort of a hybrid of that, which apparently, as I'm looking at the case, I didn't spend a lot of time on it, but I saw that there was a attempt to change an existing zoning regulation by definition. I've not seen that before, David. I don't know if that's ever been done, but if you can explain if that's something unusual to us. But I think it's a discussion that we should have. I don't know that we can do anything on it tonight because we have to decide if we're going to take one step, make sure that that is legal. And that presents the obvious question that the chair had posed. If we make it a zoning reg, we have the case. That's through Mr. Harris. We have the other idea of diminution of value of the house that might be affected by an ordinance that goes to the alderman. But just some brief thoughts on it. And as I indicated, it's not something that has not been seen around Milford at different discussions and forums when you have private associations that are trying to monitor what's going on. And then you get to the issue, lastly, which is really public health and safety, which goes back to the ordinance. And it appears that the discussions are generally involving noise, excess traffic, and as the chair pointed out, diminution of the value of the neighbors' properties by the fact that there's wild and crazy bands or parties or whatever. So those are things that would clearly fall within the health ordinances as opposed to a separate noise ordinance. But I think it's a well-framed discussion, and I appreciate the time and effort put into it, but I think we can't really decide tonight, but I think it's a good starting point, Mr. Chair.
Yeah, okay. Yeah, I think that there is there's obvious concerns. I know that I find Airbnb quite nice when I'm traveling. I've done it all over. It's just a great way to do things. When you have large groups getting together from different parts of the country, we can get a big house and all share it, and stuff that wouldn't be really available for the use that I've found valuable in hotels. And so it's kind of cool. I think there is a great value in it. As a homeowner, I can see myself at retirement wanting to travel for a month or a week or whatever and rent the house out for a short time while I travel, a house swap or Airbnb or whatever, or have, purchase a property and use it specifically for rental. And if you do that, if you can rent it out for a month or a year, I don't see the difference where you could rent it out for a day or a weekend. So I kind of feel that it's a benefit. Now, if there's a concern about parties, then I think that the alders should address parties. If there's an issue with traffic, I think the alders should address traffic in general, not specifically to how long you rent a piece of property. I mean, I think you own a piece of property, you have a right to rent it. I think that to take that right away by limiting it to a certain amount of time is, I don't know, egregious. I know that like the beach in Milford, all up and down, the 14, 16 miles, whatever it was, back in the 40s, 30s, 40s, it was really what it all was. It was rent by the week, or maybe by the month, or maybe by the weekend. People would come and they would rent a house near the beach, and a lot of them throughout the winter were empty. I mean, that's the history of Milford. It's not, the value of the history of Milford is not all pre 1800. There's a value of the 30s and 40s and 50s in Milford. I mean, that's part of our culture, the same way that that the early settlers in the 1600s that we seem to put up on such a pedestal. I mean, I just think it's kind of a cool history, and I think it's something that's great to have people be able to come to Milford for a week or two in the summer and go to the beach. So for me, I think leaving it alone is a good thing. That's just my thought. But anyone else is willing to pipe in?
Yeah, Jim, if I might.
Yes, please.
I have actually personal knowledge. There's a house across the street, I mean, literally across the street from me, that's rented weekly, monthly. And since Labor Day, it's been pretty much at least the entire time. It caught my attention because there was a different dog there every week. My dog walks by and I notice there's a different dog there every week. And I can tell you, I'm sure in the neighborhood that I'm in, there's probably been some complaints, but living directly across the street, you wouldn't know it at all. The folks that come in are generally, and again, it's only been since Labor Day, families that come in for weddings, trips, people who had lived in Milford before and had to come back for a day or two and want to make it into a week. It's been really not even an issue. In fact, if you didn't know it, you wouldn't know it. That's my 2 cents. If we're going to regulate it, though, I would punt this one to an ordinance in a second.
Well, I think that,
Not zoning.
I think that makes good sense too. And it's number one, it's enforceable. And I think that the positive, Mr. Sadi, was that a hybrid, if there was some collaboration where, I mean, I think our board would see it as a renovation or a new construction or something that had something to do with, permitting. But if somebody has an existing house in an existing neighborhood they would never come in front of us. You know, I think that, you know, I've looked at regs. I think I was up in like Pebble Beach area, and I remember there was kind of like a whole page right on the wall with, you know, here's your key code, here's the local restaurant, and here are the local regs on, you know, they call short-term rentals or whatever. And it was, you know, they're health inspected. There's a certain tax, there's a certain license that people have. I mean, I think that would be important, right? I mean, I think you have those concerns, and that it becomes somewhat of a, you know, revenue stream for the city, you know, probably not huge, but something that at least would pay for any kind of enforcement. But I think your instinct, Mr. Collegian, is good. That it's really the proper spot for it is over at the Alders.
Mr. Chair, I think that one of the things we do have to look at, though, is that, and we go back to some of the Florida regulations, and I don't know if California is like that. Pebble Beach, I think, is with California. You know, that licensing has, I suggest, two components. One may well have a zoning component, because you'd have to be, I'm assuming we have rules and regulations in the zoning. I've gone through every single page. And I know that some of you are shocked, but we must have some rules and regulations as to what is a one-family house, a two-family house, what they can be used for. You know, you can't have a two-family house with a store on the floor without going through. I know we've had different approaches here. And the other side is the licensing end of it, which, you know, you touch upon, and the question is an appropriate one. You know, who gets involved in that? At least the Florida rules look like they're all statewide. They appear to be either statewide or county. So, you know, that does impact on the ability of the municipalities to get some tax benefit from the income stream given to the homeowner. Now, I don't recall, I can't give you an exact rule on how it works, but I'm suggesting that the taxpayers in the city that are commercial may well have a different tax rate, or a different tax requirement because of their income stream, where we wouldn't normally do that for house. Again, these are just thoughts. I don't have answers to all of them, but I'm bringing them up and saying that, you know, I don't think we have a full answer yet, but that's between the three of us.
Yeah, I mean, I think it's an important topic. Obviously, there's concern throughout the city from different perspectives. I don't know if there is an example, David, of an approach that was a hybrid between the legislative body and the zoning department in a particular municipality.
I will tell you, because it came in hot in the press this evening. I was talking to a colleague in Fairfield, and theirs is considered a bit of a hybrid. In Fairfield, apparently, if you have a Airbnb or a short-term rental, there, the health department, you're supposed to get a permit each time you change a tenant. And
that seems a little bit,
yeah, and then
crazy.
And then apparently they can zoning can send out a notice of violation if they don't. But they freely admit that during the high season of summertime, no one in the town enforces it because it's unenforceable.
Yeah,
and the only time they do try to enforce something, and then again they don't appear to do it during the high season, but I'm sure there's exceptions, is when neighbors rat out their fellow neighbors, because that's the nature of zoning. Because they would never know driving by. It's one of those things that, you know, unless a neighbor reports them, they would never know. That's the zoning challenge, and that's the problem, because the real enforcement and usually the violations themselves are going to be after hours, when you know, the zoning people aren't around. You know, zoning people are on a, you know,
yeah, that was one of that was in one of the links that you sent us, is that was their argument for it being an alder or legislative act.
Exactly.
Because there's actually more teeth behind it.
Exactly. I mean, if you're gonna bother to do something, you know, I always say, you know, when we always look to create regulations, we want to be able to have to reasonably be able to enforce them if need be.
So I guess,
Mr. Chair,
yeah,
can I raise a question to Mr. Harris? Because I'm just trying to analogize the situation. So let's assume, Mr. Harris, that we have a district that's a single family home. Is there any number of people that are allowed in that home?
4 unrelated is the maximum.
How many?
4 unrelated is the maximum.
Okay. So if we recognize that they're putting up false barriers and stuff like that, the complaint would come in, it would go to the zoning enforcement officer, and then we would go forward on that if with an investigation and possibly a citation. Is that how it would normally work?
Yes, but it's hard to, if you walk up to someone's door and you think they're running an Airbnb, and
But it's an Airbnb. I want to get away from that. There's a complaint to look at. This is supposed to be 4 people in the house, and I see maybe 20 people coming and going. They're building whatever it might be. They're building false walls there. I mean, this is something it's overcrowding as opposed to 2 or 3 people.
The only way to really get a handle on it would be to get into the house. They would have to voluntarily let me in and then let me interrogate them. Who are you? Basically, show me your papers, because I don't know who these people are. They could all be related, as far as I know, and they could always say, "Well, we're all related." And the only way that I'm supposed to know is, "Well, give me your birth certificates." It's
Thank
just.
you. So my point is that we have zoning regulations in effect already that you have found over your years of being the zoning enforcement officer are hard to enforce because of the fact that you're stopped at the proverbial door.
Correct.
Yeah. I don't know how to handle it, Chairman Quish, because I don't know if it becomes a police matter, if it's a loud and noisy party, and we go back to what are the noise ordinances there. Again,
I know in my neighborhood, there's some people up the street that have loud and noisy parties. So what do? You call the police on them, and it's not has anything to do with if anyone's renting the house, it's just noisy neighbors. So it's a specific issue. A noise issue is a noise issue. Who's staying at the house is a different issue. Yeah. But so I think that there's not much we can do at this point. And I don't think there's much we want to do at this point. I think it's clearly either 100% legislative or a collaboration where there is some legislative action, maybe some licensure, some health, and maybe there is some, if it was a new building, that it would be maybe a site plan review, or it could be, I don't know. I mean, we'd have to see some other issues. The Fairfield, I wouldn't think would be an example of a best practice. It seems just creating a layer that's unenforceable. And I think to Stephen's point originally is that it doesn't make any sense at all to create any kind of language that is unenforceable. I mean, if it's unenforceable, then it's just a waste of everything. Right. It has to be legitimately in our purview to look at it, and secondarily, it has to be something that reasonably can be enforced, or else it's dumb, I think.
Right, Mr. Chair. I appreciate the recent case given by Mr. Harris to the board, but I do know that previously I was involved in a not a legal advice investigation, but an investigation to different states' practices, and I believe that what we see in Florida has been upheld legally to challenges saying you're taking my property. And I think there's been a very mixed decision across the country. So merely because we have one decision in the state of Connecticut doesn't ipso facto mean that it's unenforceable. It may well be a different reason. But that being said,
that's possible. I just think that in general, as you pointed out, if you're stopped at the door for one particular set of circumstances, like unrelated people living in a house, what are you going to do with, you're going to go to the door, and how long are you renting this place, or do you own it? What's your name? Where's your where's your license, you know? So, I mean, at one point, as a logistical conundrum is the zoning enforcement officer is not going to go to a house and say, do you own the house? Are you renting it? How long are you renting it for? I mean, it's just not, there's no capacity to get that done. I don't think.
I don't disagree with the part of the analysis. What I do ask you to consider is that we continue this to our next regularly scheduled meeting and see if there's any public input. There are members of the public that are here. We're not like the regular board meeting that we have. We have the public hearing matters and the non-public hearing matters. But again, there's certainly nothing wrong with us getting input if there wants to be any from members of the public. I see Ms. Nash is here, and I don't know if she's going to address it.
Just to remind the board, this, even though it's a subcommittee meeting, is run and handled and adjudicated just like a regular planning and zoning board meeting. And I had to double check that with our city attorney. This was not advertised as a public hearing. If you want to have public input on this topic, it would be at a next subcommittee meeting.
And that's what I was going to say, Mr. Salkus, where you gladly told me my positions. We can't do it right now, but I think that we should get some public input if they want to have any and make it available. See what the citizens want, and we can go from there.
Yep.
As opposed to, I thought the chair was considering basically taking action tonight and tabling this or taking a vote on it. That's what my suggestion.
Yeah, and I mean, I don't think there's anything really in front of us, just a conversation. So I appreciate your thoughts. Just to clarify, David, could we have a subcommittee meeting that was open for public comment, or would we need to have it be at a regularly scheduled full board?
You can have it at a subcommittee meeting as long as we advertise it as such.
Do you think it's smart to maybe it's smart to, I don't know. Well, let's think about this with two choices. If we go with Mr. Satty's suggestion that we have a public hearing, we have two choices. One, to have a public comment period or public hearing, whatever you want to call it, as just the subcommittee, or we put it on the agenda as a public discussion. Could we do that with a full board without it being an application?
Yeah, you could.
So I guess that's the question.
As long as we properly advertise it.
Yeah, so I guess that's the issue then. Do we want to hear the public and not have everyone else have to listen at a subsequent subcommittee meeting, or do we ask David to put it on the agenda for a full board meeting? Do you guys have any feelings about that?
I take no position either way. I just thought that we could have the ability to have the public, now that they know this is what we're discussing, be heard. But how we hear them, as long as it's a properly noticed meeting, I don't care.
I just want to jump in here quick because
I'm Julie,
not.
Julie,
sorry,
you
Julie, you cannot speak.
I'm not.
Julie, I'm gonna have to mute you, Julie, because this is not a public meeting. It's only a meeting.
I'm not the public.
Yeah, you are.
Exactly.
Yeah, you're not a member of the meeting, but thank you, and we want to hear from you, just not today. Any instinct, Brian, either way?
No, I agree with Mr. Satty. I think let's let him have, I don't think you're going to get a lot of attention on this. I really don't. But I think that the public has a right, and let's invite him in.
Okay, so let's do it. Let's do it as a subcommittee first. And if seems to be a pretty lot of interest, then we could have a second public meeting with the whole board. Is that okay?
That sounds like a plan.
Is that okay with the other members of the committee?
Sure.
Okay, so let's do that. And I thought we were going to have some of the quote unquote low hanging fruit tonight, but I guess not. There's some language.
The language does exist. It's just being vetted right now.
No, I mean, I'm just saying that I thought there was going to be some simple reg changes for language adjustments, what we used to call low hanging fruit in terms of changing some stuff. Let's see if we can get those on the next meeting, and let's have the meeting a month off. And we'll include some of the quote unquote low hanging fruit where we're cleaning up some reg language, as well as a public comment or public access to a conversation about short-term rentals.
Okay.
Okay. Do we need to approve minutes or?
Actually, did we send you minutes? I hope we sent you minutes.
We did.
There's still one
There
other
were-
member.
Okay.
Mr.
There
Chair,
was
there's
a
one other
link
matter
to
on the,
them.
I'm sorry, there's one other matter on the, before the approval of minutes, the member suggestions for proposed amendments, if any, that's on the
Okay, sorry
agenda.
about that. I'm not at a printer, so I didn't print out the agenda.
Okay, let me,
Go ahead.
I'll put up the agenda again. Open up, here we go.
Member suggestions for proposed amendments. Yes, that's the next order of business. Mr. Sadi.
Thank you very much. I think I raised this before in a reference to the chair's comments about minor adjustments to the regulations you described in a matter of fruit, but I had suggested, and I've made it known at the regular board meeting, that we should get and I'm not sure who's going to do it. I don't suggest to volunteer myself to do it, but find out what the changes in the law that occurred last year in the legislative session would impact any of the zoning regulations that we have. That was, I requested at least one of our earlier meetings of the subcommittee, but I think we should
You will
consider
get
that.
You're going to get that at the next subcommittee meeting. We've done that in-house. I'm just putting some finishing touches on it, but we do have.
Then I'll waste no more time of your time. I appreciate that. I look forward to it.
Just to let you know, Mr. Sadi, I've gone through the zoning book and compared the zoning book to the various changes I forgot the number at this point, 29, whatever it is, the statute numbers that most of them are under. So there's a list. I've generated a list of different sections of the book that I think need to be addressed. And at the same time, we're trying to come up with some of the regulations where we may need some new regulations where we don't have something that already exists, or changes to regulations that we currently have.
Oh, that's
Thank
great.
you.
And so as a meeting prep for next meeting, David, if you could sort of cut and paste out the section of the new regulation, the new CSG that addresses planning and zoning department, so we can look at it. And then if you could then send us again in advance your list of adjustments and changes we need to make, so we have some time to look at it and check it out ourselves before the meeting.
Yeah, I can probably, I'll check, but I might be able to actually get you some stuff tomorrow. And then.
Okay.
Look at it.
I'm not going to look at it until a couple days before the meeting, but you can get it out whenever you want.
Okay.
Okay. Any other issues? We get I guess we give motion to approve the minutes.
So Mr. Collegian was raising his hand.
Oh, I'm sorry.
Mr. Cush, I saw Mr. Collegian raising his hand.
You're muted, Brian.
I'm all set. Thank you, though, Bob.
Okay. Very good. Without objection, we approve the minutes.
That was Mr. Collegian's motion, I thought.
Okay.
Thank you. I'll second it.
And then without objection, it's done. And any other questions or comments of anybody? All right. Well, listen, thank you very much for your time tonight, and look forward to the next time we meet.
Okay.
Thank you.
Have a good evening,
Good night.
everyone.
Good night, everybody.